for BACL, also, of course, for the postgraduate workshop. We'll now start with the first of our speakers, and if we could get Benoit from the Chinese University of Hong Kong on screen and the slides up, then we can start with your talk on climate assessment as a transnational trend. Thank you very much for giving your talk, and over to you.
Thank you very much for having me. Just trying to use Zoom. Okay, so I can see you. So if there's anything that goes wrong, if you don't hear me anymore, or if I disappear, please make some signs or interrupt me. So thank you very much for having me here. It's a pleasure to visit the UK, even though virtually from Hong Kong, and to present this paper. So the paper I'm going to present is already published, but still a work in progress at the same time, because that's a topic I've been continuing to work on. The paper which is published is more of an international law paper, but what I'm going to present is the comparative law perspective in it. So just as an introduction of the content or the kind of research that I'm going to present, I think this seminar is really important, and I was very keen when I heard about the theme of this year's seminar, because I think there's a real need for comparative climate law. And that's from someone who is not really a comparative lawyer. I'm no more into the climate law research, but there is a big transformation in climate law from a focus on international law to a focus on domestic law, on the implementation of international law. Many countries, pretty much every country in the world, is now implementing laws, regulations, policies, or has some litigation on responses to climate change. It used to be limited to a few developed countries with relatively similar legal systems, but with the Paris Agreement, it's really become a global process of implementation. That means that you have similar issues in every country: how to mitigate climate change, how to adapt to climate change, how to mainstream adaptation in other laws and policies, and so on. But different jurisdictions will naturally come to different responses, and that might be appropriate when the domestic circumstances are different. However, there's very little interaction between jurisdictions at the moment. There are some cases of transplant. For instance, you look at the cap and trade mechanism that was implemented in the EU. China is now implementing something similar. So formally, there is some interaction, but that's a very formal interaction. There is little understanding of why did the EU implement a cap and trade mechanism? What have they learned on how to implement it? And is it going to work in China? So there is some formal interaction, but there's really a lack of deep mutual, deep conversation between jurisdictions, and a lack of exchange on what the first jurisdictions to implement climate law have learned. So I think there's a big benefit of comparative research, both for understanding the law from a purely scholarly perspective, but also in terms of what we now call impact. It can help to determine how better to address climate change, to know what other jurisdictions have done. So in this paper, I'm going to look at one particular issue or theme that has developed across borders. That's the use of environmental impact assessment as a tool for climate change mitigation. So I guess all of you are familiar with environmental impact assessment, and EIA is a procedure to inform decision makers about the potential potential environmental impacts of proposed activities or projects. Of course, there's a difference between EIA and strategic environmental assessment, but I'm not going to speak about that. Pretty much every country has a mandatory EIA, or at least a practice of EIA. And there are some differences between countries, but at least I think there is no EIA unless there are two things. One is a scientific assessment of the impact of the project, and the other one is some form of public consultation. And the aim of that is, of course, to consider any alternatives or alterations to the project that may reduce the environmental impact. So in this presentation, I'm going to look at how EIA can be used as a tool to mitigate climate change. That is how the climate assessment can look at greenhouse gas emissions and how the process can consider any alternatives or alterations that may help to reduce greenhouse gas emissions. That's a different topic from looking at EIA as adaptation, which is also a trend. So we here really look only at mitigation, at trying to reduce greenhouse gas emissions, trying to prevent climate change at the global level. There is clear international or transnational trend towards using EIA as a tool for climate change mitigation, or to put it shorter, towards climate assessment. Pretty much not every jurisdiction, but many jurisdictions have now a mandatory climate assessment, which means that they have adapted their EIA legislation to include an assessment of greenhouse gas emissions, an assessment of any alternatives or alterations of the project that will reduce those greenhouse gas emissions. So here I only just put very, very few examples. If you look at the paper, you will see more. One is the EU directive that was amended in 2013. So the directive on EIA and the directive on strategic environmental assessment. That's why two directives. They have been amended in 2013 with effect in 2017 to include climate change mitigation. And the Commission has developed some guidance documents. But that's just one example of rules or guidelines that integrate climate change mitigation in EIA. A much more developed guideline was adopted by the Council of Environmental Quality in the US. It has been withdrawn by the current administration, but it's still implemented in practice. But there are many other examples as well. In other jurisdictions where there has not been legislative reform, courts have made the change. So, for instance, in South Africa, without any change in the EIA statute, the High Court of South Africa has decided that an EIA on a coal plant had to consider the greenhouse gas emissions among other impacts on the environment. Again, that's just one example. There have been a lot of cases in the US, Austria, in the UK recently with the Heathrow Airport extension, and in many other jurisdictions. And in some countries or jurisdictions, there is a practice without there being a law or a formal court decision. And that's the example of China, where there's nothing about climate change in the EIA law of 2001. It's too old, it has never been revised. There's nothing in general regulations, but two very specific guidance documents mention climate or greenhouse gas emissions among the things that have to be integrated in the assessment. So we have different ways of approaching the question, but many jurisdictions are now integrating climate change in the EIA process. Now, what's interesting is that in this process, some issues appear. When you want to integrate climate change mitigation in an EIA, you have some questions that appear. One question is, in what projects are you going to look at greenhouse gas emissions? How are you going to define significant greenhouse gas emissions? Of course, you're not going to have an EIA for every single project that contributes marginally to greenhouse gas emissions. And no project that you will have a big impact on global greenhouse gas emissions. The highest share of global greenhouse gas emissions in a single project that I have ever heard about is 0.5%. So you may say that no project contributes significantly to global greenhouse gas emissions. But in that case, there will never be a use for EIA. So the first question is where to put the threshold between significant and marginal greenhouse gas emissions at the stage of screening for EIA, which projects have to go through an EIA, of scoping the EIA report, deciding whether you speak about climate change in the EIA report, and also at the stage of deciding whether the project should be authorized to proceed. A second common issue is who is going to be consulted and notified. Very often in EIA, part of EIA is about public consultation. It's about consulting the affected public, but nobody is directly affected by a small contribution to global greenhouse gas emissions. It's just a drop in the ocean. So I will come back to that as well. The third question is, how do we relate climate assessment to cap and trade mechanisms? In many jurisdictions, like in the EU, there is a cap and trade mechanism on greenhouse gas emissions. The regulator, the legislator, will impose a cap on national greenhouse gas emissions and distribute allowances. The consequence is that if you reduce emissions in one project, you free emission allowances for other projects, and you have no net benefit. It doesn't achieve any net benefit for greenhouse gas emissions, because the total greenhouse gas emissions is limited by the cap. And the fourth common issue is generally if all of this is effective or not. So a question I'm often asked is there any instances that show that climate assessment may be useful? So I have to go quite quickly through these four issues, but I will show that some jurisdictions have found some solutions to each of those issues. And what I want to show through this is that if we look at this from a comparative perspective, none of those issues is a big issue, right? All of those can be surmounted or can be solved just by comparing what different jurisdictions have done. The first issue about assessing significance, in New Zealand, in 2004, I believe, the Court of Appeal found that a project's greenhouse gas emissions was too small to be significant. It was infinitesimal. It was just a drop in the ocean, as Jacqueline Peel put it. But if you look at this in perspective, a drop in the ocean can be a drop in a thimble. It can be quite important at scale. And if you look at the benefit of a project on a global scale, very often it will be insignificant as well. One particular coal plant will not contribute significantly to global power generation. It will only have benefit at a local scale. So if you want to compare the cost and the benefits of a project, you have to look for both of them at the local scale. There are many ways of looking at the benefits, at the cost of the project on greenhouse gas emissions at the local scale. We can compare the emissions of the project with the emissions of the region where the project is implemented. We can compare with similar projects implemented in the same country or jurisdiction. We can compare with the efforts and the resources invested in reducing emissions. So if your country is investing a lot in trying to reduce to avoid a few tons of carbon dioxide, then you should consider avoiding those few tons of carbon dioxide in a different project as well. And there's also the US way of using an economic valuation, a social cost of carbon, which allows very direct comparison of the cost and the benefits of a project on a dollar value. I'm not sure which one of those four approaches is the best, but there are some solutions, and there are ways to refute the objection of the New Zealand Court of Appeal. Turning to the second question, who is going to be notified? Who is going to participate in the public participation process? This can be quite absurd sometimes. There was one case in the 2000s in Czech Republic where the government wanted to extend the lifetime of a coal plant. That's the 0.5% of global greenhouse gas emissions per year. Very big, very polluting coal plant. Under Czech law at the time, any stakeholder could intervene, including any foreign state. That was quite a unique legislation, which after that has been changed. Micronesia took advantage of this provision to intervene in the EIA process in Czech Republic. So a purely domestic EIA process, but Micronesia could use a statutory provision to intervene in the debate and to present their views, of course, against the project. What happens next is that the government was shamed by all the public attention that this created, and they decided to cancel the project. But that's kind of weird, because what is the legitimacy for Micronesia to have a say on this particular project of Czech Republic? Of course, Micronesia is affected by climate change and should have a say on the overall level of greenhouse gas emissions by Czech Republic. But what about a state having a say about a project in a different state? That seems to be a bit too far-reaching in terms of not really respecting the principle of state sovereignty, perhaps. But there are some ways around this. I think we have to ask ourselves, what is the rationale, what is the justification for public participation? If we believe that public participation is indeed about representing affected stakeholders, then I don't think that there should be public participation in that sense on the climate assessment. You will not want Micronesia to participate into any and every single project of any single coal plant or fossil fuel project everywhere in the world. That would be repetitive and not very constructive. But there's something similar under the Paris Agreement, under the UN Framework on Climate Change. There are systems for states to report, for technical experts to review the reports, and then for states to gather and speak about what they have achieved and what they should achieve through a global stocktake under the Paris Agreement. Those processes, I believe, are the equivalent of public participation, but it should not be project specific. There should be a unique process of international negotiations. At the project specific level, we may have and we should have public participation, but not as representation of stakeholders, as political deliberation. And when you think of it, EIA is often about non-human cost of project. It's about the impact of a project on ecosystems, on spaces, on areas that are not really, it's not about affecting people directly. So very often when you have any EIA and when you have public participation, people participate not to defend their own interests, but to defend what they view as a fair approach to the project. And this approach of political deliberation could readily be applied to climate change. You could have a domestic political deliberation process on the impact of one project on global greenhouse gas emissions. So my understanding is that there is no need to change anything in the EIA legislations to provide for public participation in climate assessment. Turning to the third issue, the issue of the relation between climate assessment and cap and trade mechanism. There are, to my knowledge, only 2 countries that have thought about including climate change mitigation in the EIA legislation and have decided against it. Those 2 countries are New Zealand and Kazakhstan, and both of them followed the same reasoning. Both of them were about, or thought they would be about, to implement a cap and trade mechanism. I believe that none of them has actually, but that's a different story. So they thought that if they had a cap and trade mechanism, having a climate assessment would be redundant and unnecessary. The idea is that within a cap and trade mechanism, the total emissions within the cap is limited by the cap. Therefore, reducing emissions of one project does not have any impact on the cap, on the total greenhouse gas emissions. It just frees some emission allowances that can be used by other actors at a cheaper price. So it's like a waterbed. You press somewhere and somewhere else it goes up, right? There are two objections to this reasoning. And those objections are signaled by the fact that many jurisdictions have cap and trade mechanisms and still have a climate assessment procedure. The EU, I mentioned before, has a cap and trade mechanism and has a climate assessment. California, the same. And there are other examples, I think. The reason why the EU, California, and others can have a cap and trade mechanism and a climate assessment without redundancy are twofold. One is that the cap in the cap and trade mechanism is reviewed from time to time. It's not a fixed cap. So if you reduce the demand for emission allowances, it makes it easier the following year to impose a more demanding cap and to reduce the amount of emission allowances. So if you have less pressure on your water bed, you can remove some of the water from the water bed. So you can adjust the cap. The second objection is that climate assessment has a far broader scope than cap and trade mechanism. Cap and trade mechanism never cover more than half of the territorial greenhouse gas emissions in a jurisdiction. So half of the emissions are not within the cap and trade mechanism. Cap and trade will cover big power plants, industries, but they will not cover cars and ships and planes and small sources of emissions which are more difficult to measure and verify. So a lot of emissions will not be covered by the cap and trade, and therefore there is no redundancy between cap and trade and climate assessment. Finally, the fourth issue, whether climate assessment is effective. Of course, in many cases, it is not. Mentioned before the case in South Africa, of Earthlight Africa, Johannesburg, a power plant, the approval of the project was cancelled or was voided by the court on the ground that the EIA had not considered greenhouse gas emissions. The project proponents went through the process again with an additional section in the EIA report. The project was approved and was implemented. So you may say that this was just a waste of time and resources. But you have to understand that EIA is a procedure. It does not guarantee anything. It just guarantees, it just makes sure that the decision maker is informed. Then it makes it more likely that you will have pro-environmental decisions. In some cases, climate assessment has led to the rejection of a project. And there is the somewhat controversial case of Gloucester Resources Limited in New South Wales last year, where the court confirmed the decision of the administration to reject a coal mine on the ground of its impact on climate change. That's a very controversial project because cynics would say that if you don't open this coal mine, then there will be another one opening in Queensland or somewhere else, and the total amount of greenhouse gas emissions will remain the same. And I kind of agree with that to some extent. I think if you prohibit every coal mine at some point, it will have an impact. Where I think climate assessment is the most effective is not in rejecting projects, which is very rare, but it is in the much more common instances where climate assessment leads to conditions being imposed on projects. It is a common practice in Canada, for instance, that when a project that has impact on greenhouse gas emissions is approved, there will be a condition that the project proponent has to use the best available technology. So if they have a coal mine, that's fine, but they have to recover the methane that is emitted while mining the coal and try to reduce this way perhaps by 10% the total greenhouse gas emissions of the mine. If you reduce emissions by 10% in every project, then I think climate assessment will be quite useful. So clearly, this is not a silver bullet. This is not solving climate change, but this is probably part of a toolkit in many jurisdictions which can be implemented usefully. So that would be my conclusion. Climate assessment is developing rapidly as a tool for climate change mitigation, but each jurisdiction tends to have their own kind of debate on how to adapt EIA law to include climate change mitigation. Each jurisdiction, therefore, will go through their own trial and error process. There is really a failure of jurisdictions to learn from one another in how to do this adaptation of the EIA law to use it as a tool for climate change mitigation. And I really want to present this presentation, that was way too long, sorry for that, as an example of the potential for comparative scholarship on climate law. So I suppose that most of you in the audience are not really in climate law, but more in comparative law. And I would warmly encourage you to look at climate law from a comparative perspective, because I think there is a huge potential for impactful and meaningful research in that field. Thank you very much, and sorry again for the